Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast, the podcast where we use AI to help us study for the bar exam. You can reach me at podcast@studyforthebarinyourcar.com. Also, remember, I'm a law clerk, so if you are an attorney or you know an attorney who needs some legal help in terms of motions, appeals, etc., too much work on your hands, call on me. You can reach me at hello@legalwriterandlawclerk.com. All right, so we're just going to jump right into it. So for this particular podcast, this is on contracts performance and breach and also discharge. So what happens when contracts don't go the way that they should? My AI co-hosts Claude and Maud are going to take you through the lesson. Here we go.
Welcome to this deep dive into a really crucial area of contract law: performance, breach, and discharge.
Absolutely essential stuff.
And for this session, we're very lucky. We're using comprehensive notes from Angela of the Study for the Bar in Your Car podcast. So a big thank you to Angela for sharing her expertise.
Yeah, Angela's work is fantastic. It gives us a really solid roadmap for these, fundamental concepts.
Right. So our goal today is pretty straightforward but vital, especially for those of you gearing up for the bar exam.
Definitely key topics for the bar.
We're diving deep into what happens after a contract is formed, the actual duties, the obligations.
What does it mean to actually do what you promised?
Exactly. And what constitutes fulfilling the agreement? And maybe more importantly for the exam, what are the legal consequences when things, go sideways?
Performance, breach, discharge, they come up constantly.
So let's make sure you're feeling really solid on these. We'll be dissecting conditions, both the ones clearly stated and those the courts kind of read in.
The express and the constructive ones, yeah.
And then the complexities of breach, from minor hiccups to major deal breakers.
Material versus partial breach.
And all the ways a contract can actually come to a legal end.
Okay, so where should we start? Maybe with conditions.
Good idea. Let's unpack conditions first. Think of these as the if this, then that bits in a contract.
Right. They dictate when or maybe if a party's duties kick in or get put on hold or even, disappear entirely.
Exactly. And Angela's notes give a really clear breakdown here. First up, express conditions.
Okay, express. So these are the ones actually spelled out.
Yeah, explicitly laid out in the contract itself. The parties have clearly stated them. Angela gives a great example, like a buyer agreeing to purchase a house only if they can get a mortgage below a certain interest rate.
That only if is the key phrase there.
Right. It signals an express condition.
And as Angela's outline points out, an express condition is basically a specific provision saying a duty doesn't arise unless some event happens or doesn't happen.
Or it could suspend or terminate an existing obligation too, right? Depending on the event.
Exactly. It works both ways.
And her notes mention a really common type conditions of satisfaction where, payment depends on one party being satisfied.
Ah, yes, satisfaction clauses. Now, what's interesting there, and Angela notes this, is how the law looks at satisfaction.
How so?
Well, if the contract involves something subjective, personal taste, like maybe a portrait painting,
Okay.
then the condition is met only if the person paying is honestly satisfied. They have to be acting in good faith, but it's about their genuine subjective feeling.
That makes sense. You can't really argue taste objectively.
Not easily, no. But if the satisfaction is about something more objective, like, say, mechanical fitness or utility, courts might apply a reasonable person standard.
Okay, got it. Now, Angela also talks about constructive conditions. What are those about? They sound less obvious.
They are. They're not actually written into the contract. Instead, courts imply them.
Imply them. Why?
Well, basically to ensure fairness and, make the contract work the way the parties probably intended, reasonably speaking.
Okay, like an example.
Sure. Angela's notes give a good one. Think about a lease. Even if the lease doesn't explicitly say the tenant has to tell the landlord about a needed repair, a court would likely imply a condition that the tenant must notify the landlord first before the landlord is obligated to actually make the repair.
Okay. That's just logical, right? The landlord can't fix what they don't know is broken.
Exactly. It's about fairness and the logical sequence of things.
So conditions aren't always set in stone then. Angela's notes mention they can sometimes be excused.
Precisely. There are situations where a condition doesn't have to be strictly met for the contract duty to, become active or stay active.
Okay, like what?
One big one is waiver or estoppel.
Waiver, like giving up the right.
Yeah. A party can basically say or act in a way that shows they aren't going to insist on the condition being met.
And estoppel. What's that?
Estoppel comes in. If the other party relies on that waiver, they change their position, maybe spend money or take some action, based on the idea the condition is waived.
Okay.
And if they rely on it to their detriment, meaning it would harm them if the first party suddenly changed their mind and tried to enforce the condition.
Then the first party is estopped, prevented from insisting on it.
You got it. Angela's outline also adds a nuance. A promise to waive a condition can be retracted, but only before the other party has detrimentally relied on it.
Timing is key then. Okay, what else? Angela's notes mention prevention.
Right. This one feels pretty straightforward. If you actively prevent the condition from happening.
You can't then use its failure as an excuse.
Exactly. You can't benefit from your own wrongdoing, essentially. Angela uses that example of a home buyer who just doesn't bother applying for a mortgage.
Yeah, the financing condition example.
Right. And then they try to get out of the deal saying, oh, I couldn't get financing. Well, their own failure to even try excuse the condition.
Makes sense. You caused the problem. Okay, next.
Anticipatory repudiation. This is a big one.
Anticipatory, meaning before performance is due.
Correct. It's when one party makes it crystal clear, unequivocally, before their performance date arrives, that they will not be performing their side of the bargain.
Wow, okay. So they just announced they're backing out.
Pretty much. And Angela's notes explain this can excuse the other party's conditions. They don't have to sit around waiting or get ready to perform their side if the other guy has already said they won't.
But Angela notes a limitation, right? Something about bilateral contracts.
Yes, good point. Generally, this applies fully when it's a bilateral contract and both sides still have duties left to perform.
What if one side has already done everything?
If the non-repudiating party, the one who didn't back out, has already fully performed, then this doctrine usually doesn't let them sue immediately for breach. They typically have to wait until the original performance date.
Huh. That's an important distinction for the exam, I bet.
Definitely. Angela also points out something else important. The repudiating party can sometimes take it back. They can retract their repudiation.
Oh.
They can retract unless the other party has already acted on it, like maybe they cancel the contract or they materially change their position relying on the repudiation, or just clearly said, okay, I accept your repudiation, it's final.
So you can take it back, but only if the other side hasn't already moved on.
Essentially, yes.
Okay. Angela's notes also mention prospective inability or unwillingness to perform. How's that different from anticipatory repudiation?
It's a bit less definite. It doesn't require that clear, unequivocal statement of I won't perform. It's more about having reasonable grounds to believe the other party will be unable or unwilling to perform when the time comes, maybe based on their actions or their financial situation.
So like serious doubts, but not a definite statement.
Exactly. It might give the worried party grounds to, say, demand assurances, or in some cases, it might excuse their own conditions.
Okay. And finally, Angela's outline mentions impossibility, impracticability, or frustration. We touched on this a bit with conditions being excused.
Right. If some unforeseen event happens after the contract is made, and it makes performance literally impossible.
Like the thing being sold is destroyed?
Yeah, or makes it commercially impracticable, meaning it's become so extremely difficult or expensive that it's just not feasible.
Like Angela's winery example with the drought.
Exactly. That severe drought making it almost impossible to get the grapes that could be impracticability. Or if the event completely undermines the whole purpose of the contract, that's frustration of purpose.
So these major unforeseen events can excuse conditions and even discharge the whole contract.
They often can, yes. So that covers conditions and excuses pretty well. Shall we move on to breach itself?
Yeah, let's do it. What happens when a duty isn't performed? Breach.
Okay, this is core stuff for the bar. Angela's notes break breach down into two main types. Material breach and partial breach.
Material breach sounds serious.
It is. It's a significant failure to perform. So significant that it substantially impairs the value of the contract for the other party and a non-breaching party.
And the consequences.
The big consequence is that it excuses the non-breaching party from their own remaining obligations under the contract. They don't have to perform anymore, and they can sue for damages for the total breach.
Okay. How do courts decide if a breach is material? Angela gives some factors, right?
Yeah, she lists several helpful factors. Things like how much did the injured party actually get of what they bargained for? Can damages adequately compensate them? How much has the breaching party already done?
Okay.
Was the breach willful, intentional, and what's the likelihood the breaching party will actually finish the job properly.
That willful factor seems important. Angela's notes mention courts don't like willful breaches.
Right. Her outline emphasizes that most courts are pretty reluctant to apply the doctrine of substantial performance, which we'll get to if the breach was willful. If you intentionally messed up, you get less leeway.
Okay, so that's material breach. What about partial breach?
Partial breach is, well, less serious. It's still a failure to perform, but it doesn't go to the heart of the contract. It doesn't substantially impair the overall value.
So the non-breaching party still has to.
They still have to perform their side of the deal,
Fair.
but they can sue for damages caused specifically by that partial breach.
So the contract continues, but they get compensation for the bit that went wrong.
Exactly. It's a failure, but not one that kills the whole deal. Now, this ties into Angela's point about substantial performance.
Right. You mentioned that.
Yeah. Under common law, and sometimes under UCC Article 2 for goods, though with some twist if a party has substantially performed their obligations.
Meaning they did most of it, just maybe not perfectly.
Right. Even if there are minor deviations or defects, they can still enforce the contract. They can still, get paid or demand the other party's performance.
But the other party still gets something for the defects.
Absolutely. The party who substantially performed is still liable for damages to compensate for those minor imperfections or deviations.
And Angela's notes clarify substantial here means the defect is minor, right? It doesn't defeat the main purpose of the contract.
Precisely. The core of the bargain has been delivered.
Okay. Now let's circle back quickly to anticipatory repudiation. Angela's outline reminds us that counts as a breach, too.
Yes, absolutely. That clear, upfront statement of, I'm not going to perform, is treated as an immediate breach. It gives the non-breaching party options right away.
And Angela stresses it has to be unequivocal, right? Not just, I might have trouble performing.
Exactly. Ambiguity isn't enough for repudiation. A wishy-washy statement might just give the other party grounds to demand adequate assurances that performance will happen, but it's not a full repudiation itself.
Got it. Okay, one more point under breach from Angela's notes. The obligation of good faith and fair dealing.
Ah, yes, the implied duty. This is huge. It's implied in every contract. Doesn't matter if it's common law or UCC Article 2 for goods.
And you can't waive it.
Nope. Can't contract around it. Parties must act honestly and reasonably when performing and enforcing the contract.
So even if the contract doesn't explicitly say be honest, the law says you have to be.
Pretty much. Angela gives an example like, if a seller knows about a significant defect in the goods they're selling and they don't disclose it.
That could be a breach of good faith.
It very well could be, yes. It undermines the whole basis of the agreement.
Okay, that covers breach pretty thoroughly. Let's talk about how contracts actually end. Discharge.
Right. How do the duties finally go away? Angela's notes outline several ways.
The most obvious one seems to be just doing it, performance.
Exactly. Full performance by both parties. Everyone does what they promised. Contract discharge, simple as that.
Angela also mentions tender of performance. What's that?
Tender is basically offering to perform. So I show up ready, willing, and able to do my part, even if the other party, say, wrongfully refuses to accept my performance.
Your duty might still be discharged.
It often is, yes. You did your bit by offering.
Okay. What else? Conditions, subsequent.
Right. We talked about conditions, precedent, triggering duties. A condition subsequent is an event that, if it happens, terminates an existing duty.
So the duty exists until this thing happens.
Correct.
Angela also lists illegality.
Yeah, if the contract's subject matter or performance becomes illegal after it's formed, maybe a new law is passed, the contract can be discharged.
And we already mentioned impossibility, impracticability, frustration. Those can discharge duties too, right?
Yes. As we discussed, those unforeseen events can excuse performance and lead to discharge. Angela notes if it's only partially impossible, the duty might just be discharged to that extent.
Makes sense. What about rescission?
Rescission is basically a mutual agreement to cancel the contract. Both parties agree to walk away and, ideally, return anything already exchanged, getting back to where they started.
But Angela points out there need to be duties left on both sides for this to work easily.
Generally, yes. If one party has fully performed, you can't usually have a mutual rescission without some new consideration. It's easiest when both sides still have things left to do called executory duties.
Okay. Next on Angela's list, accord and satisfaction. Sounds formal.
It's a two-step process. First, the accord. That's a new agreement. The parties agree that one will accept some different performance than what was originally promised.
Like accepting less money or maybe a different service instead.
Could be, yeah.
Yeah.
In full satisfaction of the original obligation. That's the accord.
Okay, so that's the new deal. What's the satisfaction?
Satisfaction is simply performing that new agreement, the accord. Once the new performance is completed, the original duty is discharged.
Does the new deal, the accord, need consideration?
Generally, yes. But Angela's notes highlight some nuances. Even accepting something of lesser value can work if it's, say, a different type of performance, or if it's paid early, or paid to a third party. Also, if the original debt amount was genuinely disputed.
If there was a real argument about how much was owed.
Right. Then agreeing on a compromise amount, even if lower, can be valid consideration for the accord. Angela also mentions the common situation under the UCC with checks.
The payment in full check.
Exactly. If there's a genuine dispute over the amount owed, and one party sends a check clearly marked payment in full for a lesser amount, and the other party cashes it.
That can operate as an accord and satisfaction, discharging the whole debt.
It often can, yes. Under the UCC, cashing the check under those circumstances can be acceptance of the accord.
Wow, important practical point. What if someone agrees to an accord, but then doesn't do the new performance?
Good question. Angela's outline covers this. If the debtor breaches the accord agreement, the creditor generally has a choice. They can sue either on the original contract or on the new accord agreement.
So they get options. Okay, next up, novation.
Novation is about substituting parties. It's a new contract where a new party takes the place of one of the original parties.
So like Party A and Party B have a contract, and they agree with Party C that C will take over A's duties.
Exactly. And crucially, Party B must agree to release Party A from the original obligation. Angela stresses it requires agreement from all three parties, A, B, and the new party, C. Then A is discharge.
Okay, agreement of all three. What about discharge by lapse?
This can happen, as Angela notes, when duties are concurrent conditions, meaning they're supposed to happen at the same time. Like, I give you the goods, you give me the money, simultaneously.
Right.
If the agreed day comes and goes, and neither party tenders performance, then after a reasonable time, the duties might just lapse. They expire. And if the contract said time is of the essence, they might lapse immediately.
So if nobody acts, the deal just fizzles out.
Kinda, yeah. And finally, Angela mentions discharge by release.
Just letting someone off the hook.
Basically, it's usually a written statement where one party formally gives up their rights under the contract, discharging the other party's duty. Needs to be clear, often requires consideration or might be done under seal in some jurisdictions.
Okay, that's a lot of ways a contract can end. Very comprehensive.
It covers the main scenarios you'll encounter.
Now, Angela's notes also smartly include a section on warranties, specifically for sale of goods contracts under UCC Article 2. Super relevant for many bar takers.
Absolutely critical for goods contracts. Angela breaks down express and implied warranties. Express warranties first.
Please.
Okay, express warranties are created directly by the seller. Could be through an affirmation of fact or a promise they make about the goods.
Like saying, this car gets 30 miles per gallon.
Exactly. Or by providing description of the goods or even showing a sample or model, if any of these become part of the basis of the bargain.
Meaning it was part of why the buyer bought the thing?
Essentially, yes. It induced the purchase. Angela notes a buyer doesn't necessarily have to prove they specifically relied on it, just that it was part of the overall deal basis.
Okay, so those are express, created by the seller's words or actions. What about implied warranties?
These arise automatically by law in certain situations. Angela discusses two main ones. First, the implied warranty of merchantability.
Merchantability. Sounds like it has to be sellable.
Kind of. It applies when the seller is a merchant. Angela clarifies this usually means someone who regularly deals in goods of that kind.
Okay, so not just a casual seller.
Right. And the warranty basically means the goods are fit for their ordinary purpose. You know, a toaster toasts, a chair holds weight, the basics.
Got it. Fit for ordinary use. What's the other implied warranty?
The implied warranty of fitness for a particular purpose.
Okay. Particular purpose. How's that different?
This one arises when the seller knows the specific reason the buyer needs the goods, something beyond the ordinary purpose.
Like, I need waterproof boots for hiking the Appalachian Trail.
Perfect example. And the buyer has to be relying on the seller's skill or judgment to choose or provide suitable goods for that specific purpose. If both those conditions are met, the warranty arises.
So seller knows the special purpose, buyer relies on seller's expertise.
You got it. Now, can sellers get out of these warranties? Angela covers disclaimers.
Yeah, how do they disclaim them?
Well, for implied warranties, The UCC allows it, but there are rules. You can use general language like as is or with all faults that generally knocks out implied warranties.
Okay, as is pretty common.
Very. To specifically disclaim merchantability, the language must mention merchantability, and if the disclaimer is written, it has to be conspicuous.
Conspicuous, meaning easy to see.
Right. Printed in a way a reasonable person would notice it, maybe bigger font, different color, all caps. Angela's outline notes there's a definition for this. To disclaim the fitness warranty, it must be in writing and also be conspicuous.
So, specific rules for implied warranties. What about disclaiming express warranties, the ones the seller actually made?
That's much harder. Angela's notes say attempts to negate or limit express warranties are generally ineffective if doing so would be unreasonable. If the seller made the promise and it was part of the deal, it's hard to just take it back with fine print.
So the express statement usually wins over a disclaimer.
Often, yes. The parole evidence rule can also be relevant here, whether you can even bring in evidence of a verbal promise if the written contract has a disclaimer. But generally, express warranties are tough to disclaim once made.
It's a balancing act then, protecting buyers but letting sellers define limits clearly.
Exactly what the UCC aims for.
Wow, okay. We have definitely covered a huge amount of ground today. Conditions, breach, discharge, warranties. All thanks to Angela's fantastic notes from the Study for the Bar in Your Car podcast.
It's a dense area, but hopefully breaking it down helps.
Absolutely. And remember, for all of you listening, especially those studying, getting these concepts down isn't just for the exam. This is fundamental stuff for actual legal practice.
Couldn't agree more. And maybe try applying these ideas as you go about your day. Think about agreements you're part of. Were there conditions? What would count as a breach? How might it end?
That's a great way to make it stick. And if you want to go deeper, look into specific cases on, say, material breach or good faith. Angela's notes give the framework, but cases add the real-world context.
Definitely. Keep digging into it.
Keep up the focused study, everyone. We'll be back soon with more deep dives into the law.
And maybe one final thought to chew on. How does understanding all these rules, conditions, breach, discharge, help parties before things go wrong? How can you use this knowledge to draft better contracts, manage risks, and maybe avoid disputes in the first place? Something to consider as you continue your studies.
Hey, I hope you enjoyed that. I think Claude and Maud did a pretty decent job at going through the topic of contract breach and performance and stuff like that. Anyhow, a few reminders and disclaimers. One, be safe on the road. If this is going to distract you, you might want to hit pause or listen to it at a time when you're not driving or whatever. Number two, I'm not a lawyer and I'm not giving legal advice. So I'm not an attorney. I'm not barred by any state bar. I am barred by 2 Native American tribal bars, but that's a different story. And number 3, AI isn't always correct, but I do read through my notes. I do listen to the podcast. And if there's anything that isn't correct, what I try to do is regenerate the whole podcast so that it is correct. And then that involves me going back, fixing my notes or fixing whatever isn't correct. But as far as I know, this seems all right. Then again, I'm just a law student. I'm no big expert on this, and I'm just figuring things out like you. So thank you for listening, and we'll see you on the next episode. Bye.